jury will not be sequestered.
I'm Brian Buckmeyer along with Terry Austin.
In the Weinstein case, fellow silence breakers and any
Election is moving along
Well,
here.
I'll read the verdict, says the Jesse Weber. Thanks for joining us.
We don't tend to see it as raw as this.
Good evening and welcome.
Hi, welcome back to Law and Crime Networks. For the record, my name is Bob Bianchi. I'll be taking it till 3 o'clock. So we've been following the R. Kelly trial. You know that's in federal court, so there's no cameras that are allowed there, but the Law and Crime Network certainly is covering that case, and we are in the courthouse actually doing the best we can in order to bring to you the fascinating developments of this case. As you know, he's charged with conspiracy and racketeering involving sex, interstate travel charges with underage girls. Multiple young women have testified in this particular case, giving a blow, most predict, with respect to the defense so far. At least the prosecutors are bringing out some very good information as far as their conviction that they hope to obtain is related. We have our very own Terry Austin that's there. Talked to a psychologist, Catherine Coleman, regarding the testimony thus far from the alleged victims in the case. Let's take a listen.
These women have been testifying about how they were sexually abused and assaulted and controlled. What can you tell us about the type of woman Kelly is accused of sexually abusing? What makes someone stay in that kind of situation?
Well, R. Kelly's victimology is really interesting here. So nearly all of his victims, they're young girls, many of them underage. And what stands out to me is that these were very vulnerable women. There were two, I believe it was two males that were included as well, but for the most part, very vulnerable because nearly all of them were aspiring singers. And so they see R. Kelly as this, really this celebrity, this guy who's really started and was able to make Aaliyah into the performer and celebrity that she was. And there's this hope that he can do the same thing for them. And so that's probably quite a bit of what keeps them in this relationship of, if I just stick it out a little bit longer, I can be famous too.
Exactly. We saw that Jane Doe number 5, she testified and she actually said that he physically abused her, that she got cuts from being spanked by him, that she was made to urinate in a cup and even eat feces. That sort of behavior is extreme. What would make someone continue even after that sort of behavior?
Well, you see this a lot in the cycle of abuse, whether it's with domestic violence, is that there's oftentimes this, we call it this honeymoon or this princess period that keeps people sticking around, is that they suffer abuse and then afterwards the abuser provides them with something. So, whether it's financial security, which was the case with a lot of his victims, is that he really kept them isolated and he took care of them financially and made sure that they had shelter over their heads. They did not know a world without R. Kelly in it because of the limitations that he placed on them. And so this really restricts their freedom and their ability to even think of a life without him. So this is going to keep them in that cycle of abuse.
Yeah, it really is an amazing case in terms of the cycle of abuse and how abusers go about doing the things they do. Of course, these are only allegations, but the prosecution's case, as I've indicated, has gone on pretty much without a hitch so far. It's just a deluge of evidence coming in with respect to that. Well, we'll be following that and giving you any major updates in that case. We've switched gears a little bit here about Robert Durst. Robert Durst is now on day 6.5. That's 6.5 days of cross-examination by Prosecutor Lewin. I hate to be critical. Prosecutor Lewin clearly knows his case inside and out. There's no doubt about it. But we have been talking about whether he can not Lewin himself and keep going on and on and on and bore, agitate, or disrupt his own cross-examination. 6.5 days. Unbelievable. But I'm not the only one saying it. The guests that I've had on previously aren't the only ones saying it. The judge is now indicating that he is going to give him a quote-unquote time budget on his cross-examination. That is a way of a judge saying to you, you've done enough. There's no need to continue to go on further. So even the judge in the courtroom witnessing it is indicating that. But the judge also had an interesting comment with regard to what the prosecutor has done so far with regard to the credibility of Durst on cross-examination. Let's listen to this interesting statement and exchange back and forth with regard to that.
We're talking about time now, so listen carefully. Mr. Lewin, I'm putting you on a time budget now. I'm going to tell you what the budget is, and I'm going to tell you the reason for it.
Okay.
I want you to finish your cross-examination by the end of the day tomorrow. And further questions, I would intend to sustain objection under 352 and 765 of the Evidence Code. Reason for it, and I don't know if you thought you were going to use more time than that, but do I need to explain?
Well, Your Honor, I would like to. Here's the problem. I'm restricted by the fact that Mr. Durst, in testifying, I've gone through, I'm incredibly organized. I don't waste time, but I'm stuck with the answers that he gives me. I've methodically gone through his original perjury, the way that he responds to questions. I've then gone through Kathy. I'm finishing up with Susan. I still have to do Morris Black. I still have to do the cleanup as well as everything that happened in Galveston. I cannot finish tomorrow, Your Honor, because in the end, I've got to do a competent job going through this information. I believe, Your Honor, that I would absolutely be able to finish on Tuesday. But, Your Honor, in the end, I've got to do my job. And what's happening is that Mr. Durst, in either not answering questions, making me repeat questions, coming up with material lies that I have to impeach. I can tell the court, Your Honor, that I'm almost done with the information on Susan, and then I'm moving over to Morris. But, Your Honor, how can the court, in the end, I'm not wasting any time, and I'm limited. The defendant is up there perjuring himself like none of us have ever seen. I understand that an argument could be, well, the jury understands that he's perjuring himself, so they're just going to end up disregarding the information that's there. I've got to cover Galveston, Your Honor. I've got to do a professional job in the position I'm in. You know, we've spent years and years and an incredible amount of resources trying to put this case together competently. So I'm asking for the court, Your Honor, if I went through my entire outline, I would end up not finishing until the end of next week. I'm asking to be able to have until the end of the day on Tuesday, so I can finish up what's very important testimony.
Kary Antholis is with us, editor of Crime Story and the host of Jury Duty, the Trial of Robert Durst podcast. Kary, the guy just can't pick up the clue phone. I mean, he knows his case, but he's falling into a trap of a sophomoric lawyer. The judge is telling you, stop, enough, or get to the point. The reason that he's in this position is these never-ending hypothetical questions, and he will wrestle and wrangle with every little minor detail that when he does hit a good point, he goes right past it. He doesn't really develop it. It's too much. I mean, do you agree or disagree that he is just turning the jury off? The judge is trying to help him.
Bob, I must say, I've got a lot of respect for you, but I completely disagree. I do think that there's a concern about the dwindling number of alternates on the jury, and it's a legitimate one. They started with 11, they've got 5. But on the other hand, that's a lot more than most trials start with. They're very near the end. Lewin is on a mission not just to convict Robert Durst, but to rehabilitate the Los Angeles District Attorney's Office that has seen criticism for decades, from OJ to the Menendez brothers to Robert Blake.
But Kary, let me interrupt. I'm sorry. I want to give you full opportunity. But that's not his job in the courtroom to rehabilitate the prosecutor's office. His job, and I'm telling you, as a prosecutor who's tried murder cases and had recalcitrant defendants on the stand who don't want to answer questions, Bob, is to win the case.
I hear you. That was my second point. I've got people in the courtroom every day. He is not losing this jury. This jury is hanging on every note. They're disgusted by Robert Durst. Yeah, I mean, I understand the point of view that he's over prosecuting the case. I understand that. I don't happen to think it's the case. He's got a complex thing to prove, which is that 3 murders are tied together. Robert Durst stops him, makes him repeat stuff. I just don't agree that, I mean, look, is it longer than most people would go? Absolutely. But is he damaging his case? Absolutely not. The jury is right there with him. I'm telling you, I've been in the courtroom. Other people have been in the courtroom. That jury is not buying any sympathy for Robert Durst.
Well, Kary, I got to tell you one thing, my friend. When there's an axiom in the law, whether you agree with it or not, when you stand well, stand still. So if you are, in fact, doing the job, then get out before you do something that gets yourself into trouble. In fact, the judge is even critiquing him because he, is the judge's opinion, and consistent with what you're saying, is you already destroyed the credibility of the man. Let's take a listen.
So the record should be clear that the defendant testified beginning on August 17th and testified on the 18th, that's half a day, 18th, 19th, 23rd, 24th, and 25th. It's 5.5 days. I'm sorry, that's not right. That's cross-examination. On direct examination, it was a total of 24 hours of testimony. I counted. You've been cross-examining half a day on the 17th, then the 18th, 19th, 23rd, 24th, 25th. That's 5.5 days. By tomorrow, that'll be 6.5 days. The defense presented 24 hours of testimony. You so far have used 38 hours to cross-examine. That's 150%, more than 150% of the time. So I would think the following is true. First of all, the defendant's testimony was not credible. Secondly, on day 1, it appeared that you really effectively destroyed any possible credibility of this witness. On day 3, I believe by day 3, I think you had very, very serious, I would even say profound admissions. Day 4, day 5, you're going through each of his statements to prove that every statement is false. Every statement he has made, it seems you're addressing, and you're right. I think at some point there's a limit. It doesn't seem there's any further purpose. It seems additional questioning would be an undue consumption of time. So at some point it becomes inconsistent with 765, the mode and manner of cross-examination. Your cross-examination has been effective. It has been, I would say, devastating. But to use additional time at this point is, we're losing jurors. Jurors are sending notes. And not only that, there is at some point there's a toll even on the witness. I would consider that. Now you're right, I think, about aspects of his testimony. As I said, I don't believe it was credible in the first place. But it's at this point it's almost gratuitous. I think that you have a different conception of the case, I think, than anyone else, and I understand that, but I think that it has to be proportionate. Your presentation must be proportionate with the rest of the litigation.
So, Kary, in addition to this time budget, the judge is saying that you have a different conception of this case, that you've already gotten profound and devastating admissions. I mean, certainly you'd love to hear that as a lawyer. That they're losing jurors and jury is sending notes. Now, the judge doesn't define, but isn't the judge basically saying the same thing I'm saying? When you stand well, stand still. He has gotten devastating points out here, and I got to be honest with you. You could tell me you're out there, you know your jurisdiction better than I do. It's very unusual for a judge to limit an attorney's cross-examination unless they believe there's an undue consumption of time that's wasting the court's resources. So I don't know. It seems to me the judge kind of agrees with me. Am I making a misinterpretation of that assessment?
I mean, I think you're partly right and partly not right. I think that the judge has gone through this case. It's gone on, 6 years since it was filed, and almost a year and a half since it started because of the COVID delay. The judge, wants to make sure that he finishes the trial. That's the most important thing to him. He doesn't want somebody to get COVID. He doesn't want Robert Durst to fall ill. And that is the biggest threat to what John Lewin is doing. Because as I said, these jurors are going to convict Robert Durst. I would bet a lot of money on that outcome. But I do think that the judge is looking at the clock with an eye towards all the things that they have been spared so far: COVID, illness to Durst, other issues that might come up that would prevent them from finishing the trial. And that would be the most devastating thing to this judge. And that's what the judge is looking at.
Yeah, unfortunately, we don't know that. At least I'm not sure that the judge stated those very things in the record. The rule that he referred to is dealing with attorneys and the manner in which they're going about their examination. I guess reasonable minds can differ here, but I don't disagree with you. The evidence is compelling, and despite the fact that there may very well be a conviction, we'll see what the appellate court say down the road, should there be, and doesn't necessarily mean that you got to squeeze out every single thing. Just my opinion, having tried many murder cases. However, we have to take a break and end it there for a minute there. Kary, we'll be back on the other end with you. Please stay with us. We'll be right back. Welcome back. We're covering Durst. The jury is shuffling back into the courtroom, and we're going to be resuming cross-examination by the prosecutor of Durst. Kary, let me ask you a question. There was a lot of discussion here in this case about these stipulations. There are a ton of stipulations. Are those made public, and were these really hashed out by the defense lawyers? Because I think it's a little unusual in the amount of them that are out there.
Yes, they are public, and some of them are quite stunning. And I think Robert Durst, in fact, wrote a letter to the judge objecting to a couple of the stipulations, one in particular about some of the conditional witness interviews that his lawyers allowed to be played in lieu of live testimony. Yeah, I mean, I'm really surprised by a lot of the things that the defense has stipulated to. They just allowed a lot of stuff to come in with very little challenge, and yeah, it is pretty remarkable for sure.
Yeah, I mean, typically lawyers stipulate the very little, defense lawyers, because they want to put the prosecutor through the test of having to pull all those witnesses in there. But anyway, that's what happened. We can get to that a little bit later. Let's go live to court.
I know that you will start sometime during that week to do your deliberation, and I will not tell you, no judge will ever tell you how long you should deliberate. That's entirely up to you to decide what you need to do to resolve the case. All right? So,
you know, with respect to deliberations,
yes.
In the event that there is no verdict, would we be substituting another juror, or would we be adjourning?
You're way ahead of the game. You're way ahead of the game. So, yeah, we will follow the standard procedures, all right? So, but you'll have an opportunity to deliberate during that week, and we'll see how we're doing, okay? With that, I'll note Mr. Durst is present, and his lawyers are here, Mr. DeGuerin and Mr. Chasnov. You may turn that on. Mr. Lewin is here for the people, with Mr. Bailey and Mr. Henderson and Mr. Miata. You may resume your cross-examination.
Thank you, Your Honor. Mr. Durst, yesterday, I think it was yesterday, you testified that in total, maybe it was the day before, that you had given Susan Berman approximately $275,000. Do you remember that testimony?
Yes.
You also testified yesterday when I was questioning you about your selling of a half a pound of pot to the person up in Humboldt, or a quarter of a pound, whatever it was. Do you remember being asked about why you wouldn't just give him the marijuana and why you would sell it to him? Do you remember that?
Yeah.
And you, in essence, responded that if it was one joint, you would give it to him, but any more than that, he had to buy it, correct?
Yeah, somebody wanted a quarter of a pound I would feel I was being taken advantage of if I gave it to him.
So, would you agree that if a close friend of yours who you've given a large amount of money to over the years, you become aware 5 years before they die that they are out there falsely stating that you confessed to killing your wife to them and that they cooperated in falsifying an alibi, wouldn't you believe that that person would be really taking advantage of your generosity?
Well, that person is Susan Berman, and I valued her friendship, and she did what she did.
So you're saying, Mr. Durst, that in essence you made the decision that even though she was falsely claiming that you had killed your wife to numerous people and you were aware of it, you decided that you were not only going to remain friends with her, but you were going to continue to give her large sums of money.
Correct.
Would you agree that given your other statements about how you give money to individuals that you know, that that would be different than anybody else in your life? The way you handled her?
I'm trying to think of somebody who was doing me wrong, who I continued to stay friends with. I guess Debbie Charitan used to say things about me that I did not like. And not only did I stay friends with her, but I married her.
But your wife, Debbie, in many ways, Mr. Durst, has been extremely supportive of you, correct?
Correct.
And your wife, Debbie, never was out there saying that you had falsely stating that you had murdered your wife, correct?
No, but Debbie always seemed to like to brag about what she knew about Robert Durst that nobody else knew.
So, Mr. Durst, the other area that I wanted to ask you about is you had made the comment, and you have said that you fled to Galveston because you were concerned, scared, that Janine Pirro was going to charge you with Kathy's murder, correct?
That is correct.
And you also said that you were concerned that Janine Pirro was going to charge you even though you were innocent because she wanted to make a career for herself, correct?
Correct.
And you've also said that you were aware at that time that Susan Berman had been out there for at least 5 years telling people that you had murdered your wife and that she had provided an alibi, correct?
Correct.
And you were further aware that Susan Berman was known to be your best friend, correct?
Known, I have difficulty with, but all right, she was my best friend.
Well, I mean, people knew, in other words, people who knew you and knew her, that if they had been asked, hey, who's Bob Durst's best friend? They might name Nick, they might name Susan, but she's going to be one of the people they're going to name, correct?
Correct.
And going the other way, you also would agree that you were known as one of Susan's, if not her closest friends, correct?
Correct.
So, Mr. Durst, weren't you concerned? I want you to assume for a second, you'll like this hypothetical. I want you to assume for a second that you did not kill your wife, Kathy.
I have no problem assuming that I did not kill my wife, Kathy. And I did not kill my wife, Kathy.
Okay, so I want you to assume for a moment you did not kill your wife, Kathy. Even if that were true, wouldn't you agree that the fact that your best friend is out there telling numerous people that you killed Kathy and that she helped cover it up would have represented a threat, especially when the prosecutor is out there trying to make a career for herself, that Susan would have represented a threat to you whether or not what she was saying was true?
Susan could not subpoena me. I don't see what you mean, a threat.
Let me explain. So if Susan Berman is out there and she's telling people, as you've said, that you killed your wife, you told her that, and that she helped you cover it up, if Janine Pirro is looking to charge you, if Janine Pirro talks to Susan Berman, then that's going to mean that Janine Pirro can basically say, I've got Bob Durst's best friend who's been out there for years saying he killed his wife and helped cover it up. Would you agree that even if Susan's statement is untrue, just her going around and saying it and you being aware of it is a tremendous threat to you?
I think that if Susan was formally interviewed, the person doing the interviewing would decide that she's not reliable.
You would agree, though, Mr. Durst, that if you've got a DA that you've said is out there trying to charge you with something to advance her career, then wouldn't you agree it might not matter whether Susan is actually credible? The DA might just decide, I got all this circumstantial evidence plus his best friend, I'm going to charge him.
Objection, speculative and argument.
Overruled.
I think if Janine Pirro interviewed Susan Berman, she would conclude that Susan Berman did not know what she was talking about and would not make a good witness.
You would agree, Mr. Durst, that within a couple of weeks before Susan Berman was murdered, she told you that she had been contacted by the New York authorities, correct?
I don't remember her saying New York. She was contacted by someone. I don't think she said it was New York. She just said it was an investigator.
You would agree, though, she told you she had been contacted by investigators,
correct,
police officers, who wanted to speak to her about Kathy's disappearance, correct?
I'm going to return to what I said. What she said was an investigator.
Okay. And what did you take that to mean?
What did I think that meant that day in 2000? She brought that up in the middle of a long telephone conversation when we discussed a whole bunch of other things. I don't think I took her seriously.
Well, isn't it true, Mr. Durst, that during that phone call, the way that it ended, and you told Jarecki and Smerling that?
Okay, after 6.5 days of cross-examination, we still go on with the cross of Robert Durst by Prosecutor Lewin. We're going to take a quick break here in the Law and Crime Network. We'll be right back. Welcome to Law and Crimes for the Record. We are under cross-examination by the prosecutor asking Mr. Durst questions over 6.5 days so far. Let's go live to court.
Los Angeles detectives and New York detectives, and they want to come talk to me.
And if I asked you on a scale of 1 to 100, with 1 being I'm not sure she said it, and 100 being I'm positive, you would say
100% what?
That Susan told you that.
Yeah,
100, right?
Susan definitely told me if she's been contacted by them.
Do you remember that, Mr. Durst?
Yes, and I think you've just proved that my memory between 2010 and 2015 about what happened in 1982 is a problem.
Motion to strike as non-responsive, Your Honor. Mr. Durst, in these 2 clips, you were admitting, you were saying that Susan told you, and this is, you agree, this is near the time of her death, correct?
No, one was in 2010 when I spoke to Jarecki, and one was in 2015 when I spoke to you.
No.
She died in 2000.
No, I don't mean when did you make the statement. I mean your conversation with Susan, where she said to you that New York and LA police want to come talk to her. That was near the time of her death. Obviously before she was killed, or she couldn't have told you, correct?
That was near the time of her death. So she died in 2000, and we're talking about something that happened in 2000? I thought we were talking about what I said in 2010 and 2015.
Mr. Is it your testimony that you don't understand what I'm asking you right now? Is that your testimony?
Why don't you just ask it again?
Okay. You had a conversation with Susan where she said to you, the New York and LA police want to talk to me about Kathy's disappearance, correct?
All I remember was Susan saying an investigator wants to contact me. I don't remember her saying that it was New York or that it was Los Angeles.
So you agree that in the clip I just played for you in 2015, you were very clear that it was Los Angeles and New York detectives. That's what you said, correct?
Yes, that's what I said to you.
Okay, so the next question is, you would agree that when Susan made that statement to you, when you had the conversation with her, that was very near the time, but obviously before she was murdered, correct?
Well, I don't remember when she made the statement. For all I remember, the statement could have been made a year before she died.
Would you agree, Mr. Durst, that the statement has to have been made to you after the reinvestigation begun, correct?
I could only say, I guess. I don't see why it would have to come after the reinvestigation was made public.
No, that's not what I said, that it was made public. You would agree that if the New York and LA police want to talk to Susan about Kathy's disappearance, that would only make sense if they were actually reinvestigating Kathy's disappearance, correct?
I never thought they stopped the first investigation. That was all Janine Pirro saying that she's renewing the investigation. I thought there was always an investigation.
Mr. Durst, are you aware of people being interviewed about this case between 1983 and 1999?
Yes, Nick Scarpetta repeatedly told me things that were quote-unquote happening.
When did you stop your contact with Nick Scarpetta?
Probably around 1985, 1986.
So you would agree then, between 1986 and 1999, you would agree, Mr. Durst, that you are unaware of any investigation being done in this case, correct?
I have a lot of difficulty agreeing to that. I might have been aware of something or other.
Well, if I ask you right now, what are you aware of? Can you point to anything today?
I would point at the McCormick family's wrongful death lawsuits.
Mr. Durst, didn't those wrongful death lawsuits start after you were charged in 2015?
No, the McCormick family took me to court in February of 1983 for the first time, and I've been in court with them right up to right now.
All right, Mr. Durst, I'm gonna go away from that. I'm gonna go back to the area that I was inquiring about. You would agree that Susan, in the conversation you had with her, made clear that she was going to speak to those investigators, correct?
Susan talked about talking to the investigator.
And Mr. Durst, isn't it true that once she said to you she was going to talk to the investigators, given what you have described and agreed to as her big mouth, you were concerned that whether it was true or not, she was going to say to them what she'd been telling.
All right, so Gigi Gonzalez is with us right now. Gigi, so far, what do you think about the cross-examination? How is it going as far as moving the prosecutor's ball forward? And what do you think of the manner in which the prosecutor is going about asking the questions?
Well, it's definitely moving forward. We're going to be approaching 40 hours of cross-examination versus the 24 hours of direct examination that we experienced. So we can definitely say that Lewin's moving the ball forward as far as his position is concerned. Is it going to go well for him? That's a different question, because, you know, when you have this type of long-winded cross-examination, even when you're able to land some strikes here, the jury's got to be able to jive with you and rock with you. And for as long as he's continuing forward with the questioning, that's even longer that the jurors have to stay with him, and they may be losing focus.
Kary, do you have any insights for our audience with respect to the judge and the prosecutor in the case, what their reputations are, what their experience and background is?
John, well, the prosecutor, John Lewin, as I think you've probably said, has been prosecuting mostly cold cases for 30 years. He has a tremendous record of success of putting people away. I'm not aware of many, if any, cases that he's actually lost. The judge is a, politically progressive judge. He's also, he rings a Zen kind of Buddhist chime at the end of each session. But he's also a very much by the book California judge, and is very, very well versed in California procedural law. So he and John Lewin, during the preliminary hearings and during the early parts of this trial, have sparred over Lewin's combativeness, his bluntness, and his long-windedness. But on substance, I would say 95% of the time, he's come down on the prosecution side rather than the defense's side when it comes to motions, when it comes to objections, and so on.
Mm-hmm. Yeah, well, I've said before, Kary, just so the record's clear, I mean, this prosecutor, I got to say, of anybody I've seen in a very, very long time, has a command for the facts off the top of his head and a thoroughness of knowledge of the case that's pretty unrivaled and rather impressive. The delivery, obviously, reasonable minds can differ on that. All right, guys, thank you very much for the commentary. We're going to take a quick break here on the Law and Crime Network. We'll be back with more live testimony, so please stay with us. Kary Antholis is with us, and if you're just joining us, he is the editor of Crime Story and the host of Jury Duty, the Trial of Robert Durst podcast. Kary, offline, we were talking during the break about what you referred to as quote-unquote stunning developments that came out during the cross-examination, probably very consistent with why the judge is saying you've already destroyed his credibility, but some really important stuff with regard to specifically Susan Berman. What do you got for us?
Well, yesterday, during the cross-examination, Lewin took Durst through his story of what happened on the night that he traveled down towards Los Angeles allegedly or supposedly stayed in Bakersfield and then showed up the next morning. And there were a lot of issues with his timeline, but probably the most surprising issue was that Durst said that when he touched Susan's body, it was cold, meaning that she had to have been killed hours before, otherwise the blood flow would have kept the body warm. And yet, at the same time, he said that he thought that the killer was still in the house, that he made that assertion. And it really messed up Durst's timeline. There was also the conversation about the telephone and the fact that the telephone was continuing to receive messages as late as Sunday, and this was a Saturday that Durst said he discovered the body, and Durst said that the phone didn't work. There were a lot of things that that came out yesterday that messed up Durst's timeline and really created doubt about his story.
Interesting. And in the end, the substance of what he says, Durst, is going to be important. And as you've indicated before, the juries always are very attentive to a defendant taking the stand. So let's go back live to court and let's see if Lewin could score some more points.
It was cold. I really don't know. And if I said it was one or the other, I was just speaking my mind.
I want to go back, Mr. You just said you're asking about something I never experienced. Do you recall saying that 10 seconds ago?
Yes.
Mr. Durst, isn't it true that the whole basis of your testimony, the whole basis of your statement of, I felt her cold breath, is that you are saying you did experience that? That was the point of your testimony, correct?
Objection, argumentative.
Overruled.
I think when I said breath, I was misspeaking.
Well, Mr. Durst, when you just said you're asking about something I've never experienced, isn't it true that you said that, Mr. Durst, because in a slip of the tongue, you were admitting with that statement that, Mr. Lewin, you're asking about things that did not actually happen, and that's why I'm making mistakes when I describe them. Isn't that what you meant?
I have no idea what you just testified to.
Well, I'm not testifying anything. I'm asking a question, but I'll ask it again. The statement that you just made a moment ago, which was relating to the fact that you don't have any experience with that. You know, I'm going to actually ask that I apologize. Can the question be read back? My first question. I apologize.
Please read that back.
Mr. Durst, isn't it true that the whole basis of your testimony, the whole basis of your statement of I felt her cold breath, is that you are saying...
Kary, I know you got to go soon, but what should we be looking out for, especially with respect to potential redirect examination in this case, or any other witnesses the defense may call? Any thoughts on that?
Well, I think that Dick DeGuerin is going to try to rehabilitate some of the messes that Bob Durst created during his testimony, probably regarding Jeanine Pirro and making Morris Black aware of Jeanine Pirro, probably some of the things related to the fact that he knew that Susan Berman was running around telling stories about him. I think, we're going to hear from at least one more rebuttal witness, which is Andrew Jarecki, who's going to testify about whether he gave Robert Durst the answers to the questions that he wanted. And then, my big question is probably your big question. Will the judge let Lewin go on beyond the end of the day today and let him do Monday as well?
Okay, well, we will find out. Listen, Kary, it's Kary, Antholis, Antholis. I tell you that because he has got the podcast, the Trial of Robert Durst podcast, you can find on Apple, Spotify, and Amazon. Kary, thanks so much for your opinion. We're going to take a break. We'll be right back. Right now to cross-examine the defendant. The audience should know that the judge has told the jury that this case is going to end on September 1st, that closings will occur on September 8th, and deliberations by September 13th. I point this out at this point in time because we see a little bit of a different style of cross-examination by the prosecutor, where he's a little more softer in his tone and willing to let go a little bit more. I'm being told that they just went to sidebar right now, but willing to let some things go. Gigi, this is kind of the point. I mean, Kary had an opinion that Lewin's doing a great job, and I think he's a very skilled prosecutor, and I think he's doing a very good job. Certainly knows the case very thorough. I just think that what we're seeing today could have been much more impactful to the jury, where you make the obvious point with the witness. You don't have to battle. You're not going to get the guy to say, "Oh, you got me. Yeah, I admit I lied." They know he's lying. So you just keep moving on to the next point. He's doing a little bit more of that, Lewin, right now. I'm not saying the guy's not doing a good job. He's a very good lawyer. But the fact is, this is much more effective in my mind than constantly battling out every minute detail. What are your thoughts?
I completely agree with you. I have to know I'm really impressed by Lewin's stamina, by his commitment to his strategy, his ability to recall facts like that. With that said, when you're in trial, you have to be adaptable and you got to be able to flow. And yesterday, the judge let him know, and usually you got to read between the lines with judges, right? But the judge straight up told him, you delivered devastating cross-examination. You have destroyed the defendant's credibility. When you hear those types of trigger words and you're running out of time, you got a September 1st deadline essentially, and the judge is telling you you're not going past Thursday, you've really got to pull back on your strategy and start to ebb and flow with the trial.
Yeah, so I mean, look, we've probably all been in a space. I cross-examined a defendant once for 3 days, and I had so much more to go, but I didn't want to lose the jury, and it was riveting. I agree with Kary said the jury was listening to every part of it, but I was actually at a point where I've beaten this guy up so bad, his credibility is so destroyed that if I keep going longer, I'm going to look like I'm beating up on the guy, or I just may lose something. I may step into something that harms me. How do I get out? I mean, have you ever been involved in a situation where you've done all in fact, the person may be giving you more than you even thought they'd give you, more than you had hoped for when you started, but they're that kind of witness like Durst that can keep going and going and going, and you can keep going and going and going. Should it be the Energizer bunny off, or should you be more strategic?
You got to be more strategic, even if you've got the enthusiasm to keep going with it, and a lot of times witnesses will deliver, statements on the stand that afford you the perfect knockout punch, right? And you could take that knockout punch and you could win the fight, but then what does it look like if after that knockout punch, you go in and you grapple with him on the ground and start slamming his head into the mat? You're going to look like you're beating up on the witness. You're going to look like you have too much to prove, or maybe you don't believe in the strength of your own case to recognize when you already hit the knockout punch. So I think it's best to recognize when you've made your points and to try and pull it back from there.
Right. And also what witnesses you're going to call is a very strategic move as well. I mean, you may have a bunch of witnesses out in that hallway, and just because you can doesn't mean you should. That's my axiom of trial law all the time. When you stand well, stand still. That's my second one. If you're doing a really good job, you may not want to mess it up with the witness. So very strategic calls that lawyers have to make, and be fluid and be pivoting and nimble as the case is going on. I'm told that they're done with sidebar and we're back live in court. Let's go to it.
All the participants, too, so we're all literally on the same page. I'm glad I got it. I'm glad I got it. It really helps me. Judge Gutierrez gave me a tour of his federal courtroom when he was first appointed, and I was just so jealous. I saw all this great stuff they had.
You know the cases they get. You know the cases they do, Your Honor. You would not be that jealous.
Good point.
Thanks, Your Honor.
Okay.
May I continue, Your Honor?
Wait till.
What was that? Oh.
Just share it or something, John.
Yeah.
Oh, here you go.
Yes. Yeah, I want to picture that too. That's good.
Oh, it's the same. Okay, thanks.
All right.
May I continue, Your Honor?
Hope it's worth it. Okay. Go ahead. When come in, sir? Oh, yeah. After all that, okay.
Anybody else need this, or?
Do I need to, will I need to restart?
Yeah, you would need to restart.
Okay.
It's me.
But don't wait for me. As soon as you're ready, I'll catch up with you.
All right, while we have a little pause there, Gigi, picking up on that last point that we were talking about, talk to us about the strategy that you use as to whether or not you want to do a redirect case or a rebuttal case, or even do redirect examination. What kind of pitfalls could DeGuerin be looking at by redirecting a witness like Durst, where he knows that then the prosecutor will be able to recross?
Well, you're definitely going to want to go into the points where he needs the most rehabilitation, right? So anywhere where, for example, yesterday's cross-examination on Susan Berman, the timeline regarding the Susan Berman visit, I'm definitely going to want to revisit that and address why it is he has certain memory lapses. And, try to stay light on this questioning because, like you just said, you don't want to give too much to Lewin, who is now on a time crunch. So maybe now is the time to rehabilitate him and spend your time rehabilitating them. But you're going to want to have a delicate touch with your questioning here.
Yeah, let me ask you, Gigi, with regard to all this information that the jury's hearing about Morris Black and Kathy Durst, some have opined that this is unusual with regard to a rule in federal court 404. California, it's called other act evidence. They have a different number for it, but the rules are basically the same from jurisdiction to jurisdiction. And that is that other acts of a bad character or things that you've done are typically not admissible unless they go to something to prove motive, intent, opportunity, plan, mistake, a rebut a claim or a defense. And then there's case law that then decides all the factors that are associated with that. And there's a lot of trials within trials here. Is it your feeling, your sensibility that maybe it's gone a little too much when it's on review on appeal? I mean, I know the appellate judge will be queasy about it, but is it going to pass through the appellate test?
You know, possibly, because like you just said, we're definitely in this trial inception, right? Where we can't really discuss the murder of Susan Berman without discussing the disappearance of Kathy Durst. And also in the middle of this is the death of Morris Black. So you have all of these layers that you have to go through, which I feel for any appellate judge or quite frankly, anybody rereading this record, it's going to take quite a long time to be able to even get through this entire trial, this 3-month plus long trial, an appellate review. But I think that these acts are ultimately going to, pass the sniff test because ultimately they all have something to do with each other. And I think Lewin has done a pretty good job at tying all three together.
Yeah, and of course, sometimes judges look at it overall and see whether or not the prejudicial effect outweighs the probative value at any point in time, and they can evaluate it for each individual instances of other act evidence or a combination of all of it to see whether or not the defendant got a fair trial. Certainly will be point one, I believe, of the appellate brief, should there be a conviction in this case, much like it was a major point in the Cosby case, may I add. Well, during one of the questions that are going to have to be asked in this case is whether or not Andrew Jarecki, who is the director of the Jinx, is going to come in to rebut the testimony of Robert Durst with this whole idea of whether or not he was told a lie or whether or not he was told to omit certain facts. Let's just take a quick listen with respect to the Jinx aspect of this and whether or not prosecutors are going to be, okay. So we're going to go to that clip.
And you told me when we were on the telephone that you thought that Gagarin might not want me to talk to you because he wouldn't want to see you in an interview say that you had lied to the jury in Galveston.
Well, they didn't know what I was going to say. So, I mean, they've always felt that, they got this home run now. Now, I get out there and I say something that implies that I made it all up, or that I told the lawyers and that we all got together and made it all up, or whatever. And that's a disaster. So they just wanted to stay away, and they said about a zillion times, you can't help yourself. Right now you're a free man, 100%. You say something inadvertently, and you'll find yourself charged in New York or charged in Los Angeles, and an interview is a big risk for you. Why do you want to do an interview?
At the time, you certainly said to me that you did lie to the jury in Galveston in some way, that your lawyer encouraged you to. And I think that's...
He didn't encourage me to. We went over the oath. And from day one, the oath says, you promise to tell the truth, the whole truth, and nothing but the truth. Just make sure that the ones at the end tell the truth, nothing but the truth, that you do exactly that. In terms of the whole truth, if you want to leave out something that does not, which makes you look bad if you tell it, but does not turn into an untruth, well, try it. Try it. If there's something so terrible that you don't want to say it or you think could be construed the wrong way, and just leave it out.
Gigi, this is the thing that keeps lawyers up at night is when we have high-profile clients who feel the compunction and need to speak in the court of public opinion and make statements like this. But I know a lot of people have been jumping on this statement, but what he is saying is something that I can hear a lawyer actually saying. It's don't volunteer information, answer the questions directly, because you don't want your witness to be going in various directions. And prosecutors say that, and defense lawyers say that. Do you find this to be damning in front of the jury, or is it explainable to you?
As a lawyer, it's explainable for all the things you said. When your client is going to be testifying, you let them know, what kind of questions they can anticipate and how they, should proceed with those answers. And you also warn them not to say more than they need to say. You know, if they ask you what color the sky is, just say it's what color the sky is, and don't go into any other, you know, facts or reasons as, you know, related to that question. What I found really interesting about what he said here was that his lawyers warned him not to say anything because one wrong thing misconstrued would end up with him being exactly where he is today. And if he only followed through on that advice, we wouldn't have to be here opining on, you know, these exact questions. He wouldn't be here at trial. So it's just that interview is so damning for him.
Yeah, I mean, the Jinx interview, and then you have the interview that was a marathon with Lewin. And as I've said, I can maybe argue stylistically about the manner in which it goes, but the man knows his case, and the man knows how to sew you in. And there's not anybody there to stop it, and that was very, very dangerous. Well, reckless conduct by the defendant that is probably going to come back without question to whipsaw him in front of the jury. We're going to take a quick break here on the Law and Crime Network. They will be back shortly from their break, and we will be covering it live. Stay with us, please. Welcome back to Law and Crimes. For the record, my name is Bob Bianchi. I'll be here to 3 o'clock. So we're covering the Durst case. They're on a short break right now. So it gives us an opportunity to crystallize the most important testimony that came out. And this, I think, we're going to find to be a very interesting exchange between the prosecutor and Durst with regard to a legal issue that I'd like to talk to Gigi on the other end. And it's basically the prosecutor saying or trying to emphasize to the jury there's a lot of people that die for unexplained reasons around Robert Durst. Let's take a listen.
Would you agree that whether or not you killed Kathy Durst, murdered Susan Berman, murdered Morris Black, that there are a lot of circumstances that are very difficult for you to explain?
It's irrelevant what he thinks, Dick.
Would you agree to that?
I'm not sure what you're asking me.
You're denying that you killed your wife, that you murdered Susan, and that you murdered Morris, correct?
Correct.
You're aware of all of the evidence that's been put on in this case, correct?
I don't know if I'm aware of all of it. I have a working knowledge of most of it.
And you're aware that I have been in my questions bringing up various issues in the case, correct?
You have been testifying in your questions.
Well, Mr. Durst, you've been answering those questions, and those answers to my questions are testimony. Do you understand that?
That's argument.
I know that my answers are testimony, are evidence. I am under the impression that the jurors are not supposed to view your questions as evidence.
The judge will instruct the jury, Mr. Durst. The judge has already explained that when you have a question, the question itself is not evidence. Your answers, which put the questions into perspective, and the answers which answer those questions are evidence. You would agree that whether or not you killed Kathy, whether or not you murdered Susan, whether or not you murdered Morris Black, that there is a lot of evidence in this case that is very difficult for you to account for.
That's the final argument. Argument. Object to the question.
No, overruled. But I was hoping you were getting more specifically to, in this situation, Mr. Lewin, in this specific situation, it presented a problem in the context of the other.
Right. Can you answer this question, or then I'll move to the specific?
Yes.
Can you answer my question, Mr. Durst?
I thought I was supposed to wait until the judge finished speaking, and I heard Judge Whitman say he'd like some specifics.
It's Judge Wyndham. It's not Judge Whitman.
Okay, thank you.
Sorry.
It's okay. You may you call me anything. Call me Your Honor, and you're safe. His Honor or Your Honor. That'll work. Okay.
Mr. Durst, please listen to my question. Would you agree that there is substantial evidence involving you being responsible for the death of your wife, the murder of Susan Berman, and the murder of Morris Black, which is difficult for you to explain.
I have explained it.
So you believe that you've explained that evidence. Is that your testimony?
Yes.
All right, let's move on. You were concerned about Susan speaking to New York authorities, correct?
No.
Gigi, I want to drill down on this. I told you when we were offline that this is where I see the problematic aspect. Now, I know every state's different. And I don't claim to be an expert in California law, but the laws are relatively similar. You tell me how it is down there in Florida. Other act evidence can be used not to bash the character or show propensity to commit a crime. The evidence rules typically state you cannot introduce evidence that says if you did this, you must have done that. That's the whole idea. Otherwise, we would have trials where every bad thing everyone ever did in their entire life, like the time I lost my key when I was in kindergarten, had to have it pinned to my pants for the next 10 years. My mother had, it would be coming into evidence, okay? And that rule is because the jury can become so overwhelmed by all the other instances that they may come to the conclusion, well, if he did that, and he did this, he must have done that. Now, we're talking about Morris Black, which he was acquitted of murder, but the prosecutor is basically saying the jury got it all wrong. And ladies and gentlemen of this jury, you should find that he committed the murder of Morris Black, even though Morris Black murder is not on trial because of double jeopardy reasons, and you should find that he killed Kathy Durst. Now, I'm sure the judge admitted that evidence under the rule, because if you can show that that other act evidence is not propensity, if it's not being used for propensity, but rather for something like motive or opportunity or, you know, modus operandi, sometimes they'll call it, where there's signature crimes that are so similar. So the judge found there was an exception there. But what Lewin is doing here in this questioning, and maybe it's fair game under California law, but I'm curious what you say. He's basically saying lots of people die around you, and if you did those things, you must have done this, which at least in Jersey would be, you'd be bounced to the Supreme Court on a reversal and have an ethics charge filed against you.
Yeah, in Florida here too, you know, and especially considering that that type of testimony is definitely more prejudicial. And quite frankly, you know, I'm surprised that the defense attorneys aren't yelling in their chairs, like objecting, you know, and really what comes down to it are these gotcha questions that Lewin tries to get Durst in because, you know, he's been able to do it before, so he can do it again. And by getting Durst to agree that there's substantial evidence, right, that exists that he can't explain, I mean, it's almost like he's trying to circumvent this rule to get Durst to admit to it and to get Durst to say something that, you know, gets him stuck into some mud here as far as his testimony here is concerned. So, you know, I definitely agree with you that this could present an issue for Lewin down the line.
Yeah, I mean, again, and I don't, we'll see what happens. Even when a judge allows it, I've had it happen. I've used other act evidence. I've been very judicious in how I used it. I was very careful about how I summed up to it. So I did not trip over the wire of using propensity evidence. If he did that, he must have done this. But let's assume for the sake of argument that it's fair game in California to do this. How is it possible prosecutors ever can lose a case in California?
Oh my gosh, that's a really good question. You know, it seems like if you can bring anything in, how could you lose, right? I mean, and it seems like here, that's exactly what's happening.
Yeah, and another thing that I find very interesting about, I love the question, the hypothetical question, which is, Durst rightly states he is testifying, the prosecutor, before the jury. I don't find a problem with that. I find that artful. You're basically letting the jury know what your position is through the question. I typically do it with very direct. Can you explain this? Yeah, you know, I'm basically, I don't care if the witness says yes or no. The jury's hearing my question and understands where I'm going. But Durst rightly says the legal principle, the question is not evidence, the answer is. But these answers are all based on hypothetical questions, many of which presume facts that he disagrees with as a witness. So it's just so peculiar to me. What do you think about that use of hypothetical questions in this fashion? Have you ever seen that before with a non-expert?
No, not really. And you know, I don't like the hypotheticals, right? Because I think it's such it's such a tactic, right? Where you're saying, if this happened, if you killed Kathy Durst, if you did this, wouldn't you agree that, and it just makes it so confusing. And I agree with you, Durst did state correctly that the questions are not evidence, but when you use it correctly, when you state your question in such a way, you're able to tell a story that the answer ultimately becomes, not as important as what you listen to and how you see the testifier, the witness testify to it. So it's almost like you're watching two ships pass where they're not really answering each other, not really speaking to each other. They're just kind of saying what they need to say or what they feel they need to say.
Right. Again, they're coming back pretty soon, Gigi. But earlier this week, Lewin was asking questions of Durst with regard to money that why would he give money to Susan Berman if he knew that she was alleging that he murdered his wife, Kathy Durst? Let's take a listen to that testimony.
You said for 5 years you were aware that Susan Berman was making up a lie to your mutual friends that you had murdered your wife and that she had covered it up by calling Albert Einstein, correct?
I estimated 5 years, correct.
And you mentioned 3 people. You mentioned Nick Chavin, you mentioned Julie Baumgold, and you mentioned Ainsley Pryor, correct?
Correct.
And you knew about this. You knew that that was a lie, you're saying, correct?
I knew that that was a what?
You knew that was a lie, you're saying. You didn't do that. Susan is lying by telling them that you have confessed murder to her and that she helped you cover it up, right?
Correct.
And yet you are testifying that even after knowing that, you continued to give her large amounts of money, correct?
Correct.
And you've said, I can't explain why I did it, correct?
Correct.
And you've also said, well, I'm autistic, correct?
Correct.
And I simply asked you, would you agree that for people looking at the situation, not only can't you explain it, but that it's hard to come up with a reasonable explanation why somebody would continue to give money to somebody who is falsely accusing them of murder? Would you agree?
I don't. No, I would not agree.
Tell me why you would not agree.
Because I don't know how people act.
So, Mr. Durst, you're telling me you don't know how people act. Would you agree, Mr. Durst, that rational people do not give money to individuals who are falsely accusing them of committing murder? Would you agree to that?
She was falsely accusing me of committing murder, but I felt that in most cases nobody would believe her because she was a known storyteller.
So, Gigi, I mean, let's add another layer of things. A lot of these hypothetical questions also come with a little bit of this thing where he's asking the witness to opine is about what other people would think, the believability. How would other people, view that? And again, getting to your point, why are there no objections to this? I mean, that is a classic objection. They say to a witness, how could he possibly testify about the quote unquote universe of people? I mean, it's not even a particular person. I mean, how is this going on?
Attorneys aren't objecting vigorously here. But what I will say is with this particular hypothetical, he's asking Robert Durst to step into the shoes and answer hypothetically as a rational person. When we all know that Robert Durst is anything but rational, this is one of the kookiest people that anybody has ever witnessed in their entire life. How could Robert Durst ever even hypothetically answer what a rational person would do here? And I would be interested to see the defense put up an expert on autism to see if maybe, because, of his condition, right? Or, if maybe he's still continuing to give money to Susan Berman due to to that ailment. So I'd be really interested to see that unfold. But, asking Robert Durst if he's rational or not to think like a rational person is not very rational to me.
the reasonable and ordinary Robert Durst rationality test. Yeah, who knows, right? That's a legal term for the folks out there that we throw around in law school. But Gigi, you know, it's interesting that brings up the autism point, because the prosecutor has opined that it's a possibility they may bring in an autism expert. You know, I don't know what that means and what this witness is going to testify, but it gets to my point again about strategically presenting evidence to a jury. Look, this jury either gets it or doesn't get it that Robert Durst is a liar. They either get it or they don't. The prosecutor's been allowed to get into 2 other murder cases and have free reign of beating the heck out of his character and showing propensity evidence. We'll wait for the appellate division to talk about that. There's a conviction. But why in gosh name would you then spin this case off about an autism expert when you have all that is beyond me? I'm sorry, Gigi. I wanted to ask your response to that. My question was too long. We'll have to get to it on the other end because we need to take a break, but we'll be right back. Please stay with us. During the break, they resumed court. Prosecutor Lewin going back to an area that's very important about finding Susan Berman cold, trying to get the defendant to say whether or not he considered that she had been dead for a long period of time. Defendant hesitating, not really willing to answer that question, and basically saying he can't figure out how long she was dead at that point in time. Let's go back live to court.
Also, that you think the killer killed her while you were there.
The killer might have been in the house. I never said anything about the killer killing Susan Berman while I was there.
Mr. Durst, can you explain why it would make sense for the killer to have killed her and then just hung around?
Speculation, call it speculation.
You indicated that you parked outside, correct?
Correct.
And then you came up to the door and you knocked, I think you said, for something like 5 minutes, correct?
Correct.
Well, if the killer was inside, wouldn't the killer have had ample opportunity to leave out the back door before you came in?
I think I said the killer might have still been in the house or the backyard.
So, Mr. Durst, it's also your position, your contention, correct, that the killer removed the tape note from the front door, correct?
I never said that. I don't know what happened to the note on the door, and I don't know if it was held up by tape.
Well, you testified that you believe the note was taped, so can you explain what happened to the note?
I have no idea what happened to the note.
Would you agree that if the note actually existed, that it should have been there when you returned to the door?
How would I have any idea how long the note was supposed to stay up for?
Well, your testimony was the note was there, taped, you believe, when you first entered the house. And then a few minutes later, when you made your second entry, you specifically noticed that the note was gone, correct?
Correct.
Wasn't that an attempt, Mr. Durst, to try and suggest to the jury that the killer had removed the note and was therefore in the house at the time you arrived?
Objection, argument overruled.
No.
You are aware, Mr. Durst, that Susan Berman had the same kind of stamps in her house as the stamp that was on the cadaver note. You're aware of that, correct?
What do you mean a stamp?
Well, you placed a stamp on the cadaver note to mail it, correct? Postage stamp.
Yes, I mailed the cadaver note.
And you are aware, Mr. Durst, that in Susan's house, that police found the same kind of stamps as you put on the cadaver note, correct?
This is the first time I'm being told that.
Sustained.
Under what grounds, Your Honor?
Seems fact, not evidence.
Well, Your Honor, the court is, we can put on the detective in rebuttal, so.
You may produce the evidence, confront the witness with the evidence,
All right.
or perhaps it's already,
Okay.
or perhaps there's a stipulation, not sure.
All right. You would agree, Mr. Durst, that you were not wearing gloves at any time you went to the residence, correct?
Correct.
Now, there has been a statement made in this case repeatedly that no evidence is evidence and that there was no physical evidence of your presence in the house. You agree that statement's been made, correct?
Correct.
And would you further agree that the fact that there's no physical evidence that you were in the house, you would agree that doesn't mean anything because you admitted you were in that house and touched things, correct?
Objection, argumentative.
Sustained.
Mr. Durst, did you go in the house and touch numerous items?
Yes.
And you would agree that there's no physical evidence that's been recovered that links you to the house, correct?
Correct.
Would you further agree then that the fact that there is no physical evidence that links you to the house doesn't mean you were not in the house, correct?
Objection.
I was
Sustained.
in the house.
Call for a conclusion.
Sustained.
What was the objection, Your Honor?
It's an argument. Argument. The first facts are sufficient. There's no new
All right.
fact in that.
All right, I want to go back very briefly to your knowledge, Mr. Durst, of whether Susan or not had talked to the police. I want to play, is it RD 519, Tim?
Yes.
I'm going to play RD 519, 315-15.
I'm sorry, exhibit is what number?
Part of 291.
And the objection is
352, it's been gone into ad nauseum.
overruled.
They had not contacted her. They were planning on contacting her. They had never contacted her. Oh, you know what? That might have come out in the. You knew that before I just said it right now because it came out in the show, right? Has that already come out or no? I can't remember what's out in the show. Did you know what I just told you or no? Is that a new piece?
No, I did not know that they had not contacted.
No, they had not come. They were planning on it. So I'm trying to figure out why would Susan tell you that if it hadn't happened? I mean, any idea?
If the detectives had not called her,
Mr. Durst, you would agree that when I told you that in fact Susan had never been contacted by the police as she had told you, you were quite surprised, correct?
No, I wasn't surprised at all.
Did you hear yourself say they had not contacted her? Did you hear yourself ask that question? What does that mean?
If the detectives had not called her,
All right, we're going to take a quick break here on the Law and Crime Network. We'll be back with more live testimony. Please stay with us. All right, Prosecutor and Durst sparring back and forth at what the meaning of the words of the questions the prosecutor is asking him means. Let's go back live to court.
All the details you gave, that you have no memory of making the decision to write the cadaver note at the house and then getting the paper envelope and stamps from Susan's.
I definitely, absolutely did not write the cadaver note in the house.
Now, my question is, though, is if you've said that you might have gotten the paper, the envelope, and the stamp from Susan's house, correct? You might have, is that right?
I do not recall getting a stamp from Susan's house. I do not recall getting a stamp anywhere. And I do not recall where I got the envelope. In the SUV, I had writing paper and a pen.
Did you have an envelope and a stamp in the SUV?
No.
So, Mr. Durst, I want you to assume that the stamps that were inside of Susan's house were the same kind of stamp as you had on the cadaver note. So my question to you would be, could you have gotten the stamp from inside the house?
Objection to improper hypothetical evidence.
Sustained.
Not based
All right.
on-
Sustained.
Yeah, Your Honor, we're going to mark item 14 is going to be Susan Berman's appointment book.
No, it's not 14.
Oh,
What's the next in order, Your Honor?
325.
So we have an envelope. It's marked item number 4. I'm going to mark this envelope as people 325. Removing the contents is a black appointment planner, and inside the appointment planner are 2 books of stamps. I'm removing the 2 books of stamps.
And display the big ones. This is not in evidence, Your Honor.
Right, he's going to display it to you, and it's going to be in evidence in a minute, I think.
Is there a sponsor?
We don't, we're not that formal here in California. It's not a sponsor. It's so you may show them the exhibit, proposed exhibit.
We have a sidebar on this, Your Honor?
No, he's going to display it to the witness and see if he.
So okay. These 2 books of stamps I removed. Should I mark these separately?
I think you can mark. Are those?
I took them out of the black book.
Oh, separate from the black book. Should you mark them? Yes. Let's make them right. 325A.
Your Honor, we're behind on time. We are going to pose it as sidebar. There's no.
Yeah. No, I don't understand. I'm overruling the objection.
And People's 130 I'm going to put on the screen as well.
Mr. Durst, can you see those 2 different items, the stamps on one side?
Your Honor, we seriously need to have a sidebar about this.
All right, let's go sidebar.
For the record, I'm placing the appointment book back in the envelope.
Gigi, okay, we're at another sidebar break here. Really, really long examination of Robert Durst. How much of this are you following along, or do you find yourself blanking out every now and again?
Not as often as maybe some of the jurors, but I do find myself spacing out a little bit, and especially with, just his hypotheticals and, the way he, do you agree on this? Even though no reasonable defendant would actually agree to that, right? No rational person would. It's just, I'm really thankful that the jurors are sitting there and muscling through it, because I know it's a hard job.
Yeah, the jury trials will be tried too. I mean, at a certain point in time, even though the jurors are told not to speak about the case, I mean, they're formulating opinions in your mind, in their mind. You know that. Where do you think it falls right now? Team prosecution or team defense in terms of how the jurors are thinking?
I think they're leaning to Team State. There's definitely been some devastating moments that Lewin's been able to crush Durst on, and even today, the fact when he went into the no evidence is evidence line of questioning. At first, when as a defense attorney, your spidey senses start tingling, like, hey, wait a minute, like, don't start laying that type of standard down. But then, it goes to show that Robert Durst was actually in the house. He admits it, but then none of his physical DNA is in there. And now his statement is being used against him in this case. So you hear these types of punches as a juror, and you can't help but rock with the state.
Yeah, and getting back to, whether it's right or wrong, I mean, how does a juror overcome the question that Lewin asked, which is the propensity question? a lot of people wind up dead or missing around you. I mean, that's a pretty compelling argument to make, whether it's legal at the end of the day or not. From a practical standpoint, the jurors have got to be saying where there's smoke, there's fire, and then he winds up in the house of Susan Berman writing a cadaver note. I mean, that's pretty powerful evidence in and of itself.
Yeah, absolutely. And listen, you can't unhear what you hear, right? You might hear the judge say, hey, strike that, disregard that. But at the end of the day, you heard it, and it's going to influence your decision-making skills and, your comprehension of the case. So you hear something like that, and then you hear Durst's answer, and, it really gets your wheels rolling as a juror.
Yeah, 10 seconds or less. Was it a good idea for Durst to take the stand?
No, not a good idea at all.
Yeah, so, I mean, originally we were thinking to ourselves, Gigi, that this was a commitment that was made in the opening statement, which is a real bold move by the defense because you want to see how the prosecution case unfolds. And they may have had some arguments in summation that they could have made had Durst not taken the stand. But now the whole case veers towards Durst. All right, Gigi, always doing a great job. Greatly appreciated. We're going to come back with more live testimony on the other end of the break. So please stay with us. We'll be right back. Prosecutor attacking Durst on the statements that he's previously made that only the killer would have been able to write the cadaver note. Let's go back live to court.
Correct.
And Susan Berman is Jewish, correct?
Correct.
And you were aware that under Jewish tradition, the body has to be buried very quickly after death, correct?
Correct.
And you would have known that that would have been important to Susie, correct?
Susan wasn't that religious, so I don't know.
Well, Mr. Durst, when you say Susan is not that religious, in your experience growing up with many Jewish people who are religious, unreligious, etc., wouldn't you agree that most Jewish people that you know, when they die, they are buried within a very short time of their death? Isn't that your experience?
No.
Well, Mr. Durst, you are someone who has expressed an interest in the Jewish religion, correct?
Correct.
And it would be important for you that Susan was buried according to Jewish tradition near the time that she was killed, correct?
Correct.
And Mr. Durst, you mentioned to Andrew Jarecki, you're the one who brought up the idea, correct, Mr. Durst, that this was a note that only the killer could have written, correct?
I think he brought it up with me.
Well, you would agree in this clip, Mr. Durst, you are explaining, first of all, in this clip, and you agree, Mr. Durst, that none of the footage, you've already stipulated that none of the footage from Andrew Jarecki and Mark Smerling that we've shown to this jury, you're aware that we've stipulated, both sides, that none of it is edited, correct? You're aware of that, correct?
No, I'm not aware of that.
Your Honor, will the court, I think
You stipulated, the jury will receive the stipulation.
at this point, Your Honor, I'm going to
It's
ask
in
the
evidence.
court to just instruct the jury of that stipulation.
No, it's evidence. I'm
Okay.
not going to focus
All
on
right.
any particular evidence.
All right.
They'll receive it.
Okay. Mr. Durst, there has been a stipulation by your lawyers, signed by both sides, that you have stipulated that, in fact, the recordings that have been played in this trial, that all of them are unedited. Are you aware of that?
All of the conversations I had with Andrew Jarecki were not recorded.
No, so we're only talking about, Mr. Durst, we're only talking about the recorded conversations.
I'm saying I had conversations with Andrew Jarecki that were not recorded.
There's no stipulation about unrecorded conversations, Mr. Durst, other than what's been entered. What I'm saying to you is, do you agree? I just played you a clip that had your voice and Andrew Jarecki speaking, and you would agree that clip is unedited, correct? That's what you said and that's what he said, correct?
I accept that it's unedited.
Okay, and in that clip, you were discussing that nobody would rob Susie because she didn't have anything. And then you yourself brought up, you said, and they're taking a big risk, correct?
This was at Andrew's urging.
This is your interview with Andrew, December 13, 2010. You said, quote, and now you're taking this big risk. That's what you said, correct?
That is what I said.
And then you were asked, what's the risk? And you said, quote, writing a note to the police that only the killer could have written. Those were your words, correct?
Those were my words, which I said at Andrew's instigation.
Okay, so you also then mentioned immediately after that, the next line is, so somebody would have to be my rabbi, although I don't see him getting involved in any kind of a killing. He might feel it's that important that it be buried right away. But I think you've got to be pretty Jewish religious to feel that way. You said that, correct?
Is that a quote from what? If that's a quote that the stipulation referred to, then that's correct, but I don't recall that.
Well, that's the clip I just played for you a moment ago. I just read, that's the same clip I played. You heard the clip I played a moment ago.
Sort of.
Well, do you need me to play it again?
Sure, play it again.
Okay.
First of all, somebody had a plan to do this, they had to go to her house, do what they did. I mean, if I was going to rob somebody or burglarize a house, I wouldn't, if they vetted Susie's, and they wouldn't have picked Susie because there was nothing there of value. I mean, I assume her jewelry was there. I have no idea if she hid it, but that's the wrong house to burglarize. And now you're taking this big risk.
What's the risk?
What?
Which big risk?
You're writing a note to the police that only the killer could have written. So, I just, somebody would have to be my rabbi, although I don't see him getting involved in any kind of killing. He might feel that it's that important that it be buried right away. But I think you've got to be pretty Jewish, religious to feel that way.
That's what you said, correct?
That's what I said.
And you would agree, the second part of it, talking about that the person who sent it and relating that to wanting Susan to be buried right away, that was you actually admitting to something that was true, correct?
That was actually admitting to something that was true. I don't know what I was admitting was true.
Well, you were admitting, Mr. Durst, that the reason that you sent the cadaver note is that you wanted Susan's body recovered, correct?
Correct.
But Mr. Durst, you are disputing the idea that the first statement that you made, that it was a note that only the killer could have written, you're admitting that you said that, but you're now saying that isn't true. Is that correct?
I'm saying I made that statement because Andrew Jarecki asked me to make that statement.
Well, Mr. Durst, isn't it true that you said the same thing during your 2015 interview in New Orleans with me?
I don't know what I have no knowledge of saying what I told Andrew in 2010 being what I told you in 2015.
Isn't it true, Mr. Durst, that in 2015 you agreed that whoever sent the note had to be involved in Susan's killing, but you said there could have been 2 people? Do you recall that?
I remember that discussion.
Right. RD 372, 315-15, page 89, lines 10 through 24.
First of all, you agree, as you sit here today, you agree that whoever wrote that letter, they killed Susan. Agreed?
You see, I don't know that. I mean, maybe there were 2 people who killed Susan.
Okay.
It doesn't have to be one person. There could be 2 people. One person could go into the house to shoot Susan, and the other person could be the driver.
Okay. No, let me. This is what I mean. Whether the person was the shooter or the driver, whoever wrote the note was a part of killing her.
Yes.
You agree, right?
Yes.
No question, right?
Whoever wrote that note had to be involved in Susan's death.
That's what you said, correct, Mr. Durst?
I told you what you wanted to hear.
So you're saying you said it to Andrew because he told you to say it, and you said it to me. Is this a part of your plea bargaining discussions?
Correct.
Well, Mr. Durst, if it's a part of your plea bargaining discussions, and you're saying that whoever wrote the note had to be involved in Susan's death, if it's a part of plea bargaining discussions, wouldn't you have to tell me I'm the one who wrote the note?
If we were going to actually do a plea bargain, I'm sure it would have come up and I would have been asked to sign something.
Okay. Again, well, isn't it true, Mr. Durst, that as you are making these statements, both times, you're saying a note that only the killer could have written, that you are saying this, Mr. Durst, because you knew that, in fact, that was a note written by the killer. Isn't that why you said that?
I did not know it was a note written by the killer.
I'm sorry.
Let me look again. I don't think so. Look at it written. You're saying this because you know that was a note written by the killer. You said that. Argumentative overruled.
And Mr. Durst, isn't it true that the reason that you denied writing the cadaver note for 20 years was because you never imagined that there would ever be compelling evidence that would force you to admit you wrote it, correct?
No, that's not correct.
What did you mean about one person being the shooter and one person being the driver?
I was answering your question.
So, Mr. Durst, again, if you were looking for a plea bargain, what is the story with now 2 people being involved? Were you just trying to throw me off during the conversation?
I was responding to your saying that only the killer could have written the note. And I said, well, there could have been 2 people involved.
Mr. Durst, during your 2010 interview with Andrew Jarecki and Mark Smerling, do you recall being asked whether it made sense for people to suspect you of involvement in Susan's murder?
No.
RD 401, 12, 13, 10, page 691, lines 13 through 20.
Part of 260. Part of 269, Your Honor. 269.
That you, oh, sure, I mean, because she was my spokesman, all of a sudden she's dead right after Janine Pirro's doing the investigation. I shut her up.
So, Mr. Durst, you were asked, does it make sense to you that there were people that suspected you? And your response was, oh, sure, I mean, maybe because she was my spokesman and all of a sudden she's dead right after Janine Pirro's doing the investigation of me, that I shut her up. That's what you said, correct?
Correct.
And you would agree that that motive would be the same motive that I asked you about earlier this morning about Susan Berman potentially talking to Janine Pirro, correct?
You asked about Susan Berman being interviewed by Janine Pirro, and I said if Janine Pirro interviewed Susan, she would find that Susan was not credible.
Well, Mr. Durst, but you agree that you were asked if it made sense to you that people suspected you of Susan's murder, and your response was that, yeah, that makes sense because she was my spokesperson. All of a sudden, she's dead right after Janine Pirro is doing the investigation of me, that I shut her up. That's what you said, correct? Those are your words.
Correct.
So aren't you, Mr. Durst, in that statement, aren't you, to Andrew directly, saying during this phone call of June 12, 2015, strike that, that's an incorrect date. During that phone call, aren't you saying that's exactly what occurred? That in fact, you shut Susan Berman up because she had information and you were afraid of Janine Pirro. Isn't that what you're saying in that exchange with Andrew Jarecki?
No.
All right. I want to talk for a moment about this plan to have Susan move in with you. When is the first time that you ever mentioned the plan to have Susan move in with you to your place on Telegraph in San Francisco?
All right, we're going to take a quick break here, but we will come back live with more of this cross-examination on the other end, so please stay with us. A prosecutor cross-examining on stipulations, prior testimony, giving Durst a run for his money on that witness stand. Let's go back live to court.
Mr. Durst, when was your meeting supposed to be with Mike Yoshida?
Are we talking about back in 2000?
Yes, you had mentioned there was going to be a meeting, I think, up at Big Sur with Mike Yoshida and Susan.
Yes, our plans were to leave Los Angeles on December 27th. Susan's plans and my plans. And to drive up to Big Sur and have dinner with Susan's friends at a restaurant called the Panthy, and then stay overnight in Big Sur at the Big Sur Inn. And then on the morning of the 28th, to drive to San Francisco and meet Mike Yoshida at the townhouse I had bought at 52 Telegraph Place.
And it's your testimony that Mr. Yoshida was aware of these plans, correct?
Correct.
Mr. Durst, I want to go back to the night of December the 22nd when you arrived at the house. the plan was for you and Susan to go over to the Chateau Marmont, correct?
I did not get to Susan's house on December 22nd. I got a migraine headache and I stopped at a motel in Bakersfield.
Right, no, I didn't ask you.
I did not get to Susan's house until the 23rd.
No, but the original plan was for you to get there late on the 22nd. We talked sometime between midnight and 1 a.m. and then to stay at the Chateau Marmont, correct? You were going to pick her up and take her to the Chateau Marmont, correct?
Correct, but when we made our plans, I was intending to leave before 11 a.m.
Right. Given that you were not leaving till 11 a.m. and given your admitted cheapness, how come you didn't call Susan and tell her, hey, you should cancel our very expensive room at the Chateau Marmont for tonight?
Yesterday. No, he's making reference to our
Reservations at Chateau Marmont and all that.
Okay, just a moment. You may briefly cover this if it's leading to something else.
Yes, it is. Mr. Durst, how come you didn't have Susan cancel the reservation when you realized you were leaving late? Why didn't you call her and say, hey, Susan, and I'm talking about at 11 a.m., because you knew at that point, you knew how long the drive was, you're not going to get there till midnight. How come you didn't have her cancel it?
I never thought about canceling it.
By the way, what was going to happen to the dogs when you were staying at the Chateau Marmont?
Niles Brenner was going to take care of them, was going to walk them and feed them.
Is that a detail you've ever mentioned before?
Now, wait a minute. While we were in Big Sur and the 27th and the 28th, Niles Brenner was going to walk and feed the dogs. While we were staying in Chateau Marmont, I assumed Susan intended to walk and feed the dogs.
So the plan was you were going to pick up Susan at midnight, go over to the Chateau Marmont, and then she was going to be going back and forth all the way to the Beverly Hills area to feed and let out her 3 dogs. Is that your testimony?
You're making it seem like the Chateau Marmont and Susan's house are hundreds of miles apart. It's a short drive, 5 or 10 minutes, whatever it is.
You think to go from West Hollywood to Beverly Hills during times in the day is a 5-minute drive? Is that
10 minutes, 15 minutes, whatever you want. That is what I think Susan was planning on doing.
So your testimony now is there really isn't an answer. You're simply saying that whatever will fit into your narrative, that's what you were going to do. Is that what your last answer meant? Mr. Durst, so what were you going to do with those 3 dogs during the entire trip up to Northern California?
We were going to Northern California the day of the 27th, and Susan was going to get back to Los Angeles in the afternoon of the 28th.
I thought you were meeting with...
in the morning.
Oh, in the morning. And how was
she?
And how was she getting back?
She was going to fly.
Well, Mr. Durst, you traditionally almost always buy all of your plane reservations well in advance, correct?
she was going to fly.
And were you paying for her flight, I assume?
I'm sure she would have paid for her own flight.
Are you aware that Susan Berman had money at that time to be paying for flights?
It never came up. We made the plans to drive up, and when we got to San Francisco, we were going to meet at 52 Telegraph Place with Mike Yoshida for 2 hours. She had asked me when she should schedule her flight, and I said anytime after 4.
So you remember, sitting here right now, you remember the exact amount of time you were supposed to have your meeting with Mike Yoshida, correct? Is that correct?
We were supposed to meet Mike Yoshida at noon.
And
I guess it would be finished in 2 hours, making it 2 p.m. I told Susan she should schedule her flight after 4 p.m. to give her lots of time to get to the airport.
And Susan knew about these plans well in advance, correct?
Yes.
Mr. Durst, are you aware of Susan Berman making any flight reservations to fly from San Francisco to Los Angeles?
I'm not aware that she made reservations or not.
Are you aware of her making any arrangements to have somebody pick her up at the airport?
I was going to drive her to the airport. What she was going to do in Los Angeles, I really did not know.
And you've already testified that this trip up to Big Sur in San Francisco was going to start on what day? When were you leaving?
The 27th of December.
And where was Susan spending Christmas?
She was meeting friends for New Year's Eve, and she was going to Denny Marcus's for not New Year's Eve, Christmas Eve. And she was meeting Denny Marcus during the day of Christmas.
Would you agree, Mr. Durst, that this new information about Niall Brenner taking care of the dogs has never been mentioned to you, by you? It wasn't mentioned by you in direct examination, correct?
I don't agree. I do not. It wasn't mentioned during direct examination because probably I was not asked during direct examination.
I didn't ask whether you were asked about it. I asked you, have you ever mentioned this story with Niall Brenner until right today, sitting on the witness stand?
Well, I might have mentioned it to you in 2015 when you interviewed me.
Well, Mr. Durst, if you had mentioned that in 2015 and you've heard the interview played in court, don't you think you would have heard that being mentioned?
All right, Gigi, what's the importance of this? Lewin was doing, I think, a pretty good job at making his point, not waiting to break Durst down, but the jury clearly knew where he was going, but he's really drilling in on this point. Why?
Yeah, that's a really good question. I think he's trying to catch Durst in some sort of other lie or some other mix-up to prove that, Durst's timeline of events just really doesn't make sense.
Yeah, and I thought Durst was going to say when he asked him, do you remember talking about in direct examination? He was going to say something like, well, that was so long ago, I don't even remember. But man, this guy's been on the stand a long time. All right, we're going to take a quick break here on the Law and Crime Network. We'll be right back. Please stay with us. All right, they're still going on the cross-examination of prosecutor with Mr. Durst. The prosecutor scoring points, a little bit of a different tone and temperament as to how he's going about this because the judge put him on a short leash. But getting pretty effective evidence out on the behalf of the state. Let's take a listen.
What, are you asking me something about Thursday the 28th?
No. Do you know who David Eisenman is? Do you know who that is?
I recognize the name as someone who was a friend of Susan.
Do you remember, Mr. Durst, he testified in this case? He's her hairdresser. Do you recall? He testified in this trial. Do you remember, Mr. Durst?
No.
You don't remember Susan's hairstylist, David Eisenman, testifying at all?
I did not know he was Susan's hairstyle.
Your Honor.
Now I'm remembering.
Your Honor.
The guy said he made friends with Susan,
Sorry.
the hairstylist.
Apologize.
So is he a hairstylist or a friend? I think they're both reasonable.
Okay. For the record, the day planner came out of People's 325, and from the day planner on this page, which is open to December 28th, is a business card that I was going to just note is in here. David Eisenman Hair Studio says December 28th at 11, and then on the 28th it says 11 David.
Do you see that, Mr. Durst? Do you see that, Mr. Durst?
Yes, I see that.
Would you agree that on the 27th and 28th, according to your testimony, Susan is supposed to be with you up in Big Sur in San Francisco? Is that correct?
We were supposed to leave around noon and meet friends of her for dinner in the Panthy at 8 p.m.
So if
then
you
we were going to go to the Big Sur Inn.
right, going back to the 27th, you can see that she has plans. Go back to to 27th, please.
Yes.
She's got plans at 11 a.m. with Tom Patton. Do you see that?
I see that.
Can you explain, Mr. Durst, how it is that she has plans in her planner book on the 27th at 11 a.m. with Tom Patton, and yet you're supposed to be up in Big Sur in San Francisco with her? Can you explain that?
On the 27th at noon, we were going to drive up to Big Sur.
So you're saying that she could have still made her appointment with Tom Patton, is that correct?
For all I know, her appointment with Tom Patty was on the telephone.
Okay, let's go to...
How about Christmas?
Yeah, no, let's go back to the 28th for a second. So she's got a hair appointment with David Eisenman on the 28th. Do you see that crossed out at all?
No.
How's she going to make that hair appointment on the 28th when she's up in San Francisco?
She wasn't going to be able to see David Eisenman.
For the record, on the 29th, there are items crossed off.
Can you see on the 29th?
I'm sorry, on the 28th, will you zoom in? I think I see a notation there on the 28th. Okay, thank you.
On the 29th, Mr. Durst, you would agree that she has items which are difficult to read, but there are things that are crossed out. Do you see that?
Yeah, I see what's up the screen.
And would you agree that that would appear to be, Mr. Durst, an indication that Susan Berman has crossed something out relating to her activities? Would you agree that's what it appears to be?
It appears to be what it is.
Okay, let's go back to the 25th, please.
For the record, it says 25th, Monday, Susie H.
Are you aware that Susan had plans on the 25th to see her friend Susie Harmon?
You saying she's going to see Susan Harmon for Christmas?
are you aware that Susie Harmon testified as well about plans with Susie Berman on that date? Would you agree?
What Susan told me was that her Christmas plans for the day of Christmas were with Danny Marcus. She said she had Christmas Eve with somebody else whose name I don't remember.
Mr. Durst, we're going to go turn to the 22nd. This is the day that you originally were supposed to meet Susie Berman. Is that correct?
Correct.
For the record, Your Honor, on the 22nd, let me just zoom out. This entire page has entries, sorry, and then the entries have taped Post-its over them, so there'll be entries under the Post-its. I'm calling them Post-its. They're actually pieces of paper taped on there. And so there's entries, original entries.
Anticipating the invention of Post-its?
Exactly. So just to describe for the record, so on the 22nd, there are entries underneath this white piece of paper, and then there's a piece of paper taped over those entries with new entries marked.
And Mr. Durst, I'm not going to go through everything on the 22nd, but it says at 4:30, it says Rich Markey. Would you agree? Would you agree? Would you agree, Mr. Durst?
I don't see Markey.
We're talking right here.
That's Markey. Well, if that's Markey, that's Markey. It doesn't read like Markey to me.
So, Mr. Durst, there also is a notation that says call Ellen right below, it looks like. Do you see that?
Do you see that? I don't see that. That looks like call Ellen.
Yes, that's what I said. Do you see any notation on the 22nd, Mr. Durst, that references you?
I can't read the stuff that's crossed out. I do not specifically see anything describing the fact that I was going to arrive that evening.
It appears to say glasses and coat. Would you agree? And then it mentions some names, including Tom. You would agree it does not appear to have anything about either Bobby Durst or the Chateau Marmont, correct?
All right, we're going to take a quick break here at the Law and Crime Network, and we will come back with more of the live testimony and cross-examination of Mr. Durst. We'll be right back. Okay, here we go. Continued cross-examination of Robert Durst by Prosecutor Lewin. Not expected to end today or anytime soon by my estimation, but let's go back live to court.
Any staycation with Susan, correct?
I do not see anything specific about our plans for the staycation.
And underneath, Mr. Durst, would you agree that, again, nothing about Chateau Marmont or a staycation or you, correct?
I see nothing about Chateau Marmont.
It
or any
mentions,
of the things we were going to do for the days we were going to have a staycation.
You would agree that it appears that Susan Berman will put in her day planner some pretty mundane things, correct? Is that correct?
Susan would definitely put in her planner some things. I sort of doubt she put in her planner everything.
And you would agree that the more you're looking at it, you would agree it appears to be Susan's handwriting, correct?
I've already said it looks like her handwriting.
Well, and then I asked you, Mr. Durst, is there anything about the handwriting that leads you to believe that it is not Susan's writing?
Isn't this a question for the handwriting expert?
Well, if you remember,
How can
Mr.
I say it's not her handwriting when I've already said it might be her handwriting?
That's not my question. My question, Mr. Durst, is does it appear to you, not being a handwriting expert, that it looks like Susan Berman's handwriting?
Oh, I don't know what your question is.
You don't know my question is. Let me say it as plainly as I can. As a non-expert, which you are allowed to be in California, you can actually give an opinion about somebody's handwriting in California. Does it appear to you, knowing Susan Berman, does that appear to be her handwriting?
I think this is either the third or fourth time I'm going to tell you that it might be Susan Berman's handwriting.
Okay. Let's go to the 28th, Mr. Durst. This is when we should have the meeting with Mike Yoshida and the return flight to Los Angeles, correct?
No, she could not have gone to the hairdresser on the 28th unless they had an appointment at night.
When you would agree, Mr. Durst, that there's also no indication on the 28th that she's meeting with Mike Yoshida, correct? Is that correct?
There's nothing about our staycation on the pages you've shown me.
And would you agree there's also nothing regarding a plane flight back to Los Angeles from San Francisco, agreed?
Correct.
There's nothing about Niall Brenner and the dogs, correct?
Well, that would have been between her and Niles. I guess she could have put in the planner Niall taking dogs out or something like that.
Well, she says groceries in the planner, correct? You saw that, right?
Grocery?
You saw GROC, a notation. She notates the word gross, which appears to stand for grocery, correct?
He's got the gardener in there.
Okay, Gigi, our time is coming near to a close. So I know we've exhaustively gone over the questions and the manner in which the examinations are occurring. I'm seeing a different Lewin here, moving a little bit more briskly. Is that him recognizing that I've already scored points? Or is he listening to the judge that I've got a time limitation here? I got to get to the good stuff as quickly as I can because I'm making the point to the jury. It doesn't make a difference what Durst says. The jury gets it through my questions. What do you think, Gigi?
I think it's a little bit of both. You know, I think he definitely heard the judge when the judge explained to him that he's already delivered a devastating cross-examination and that he's going to be operating on a deadline here. And I think Lewin is trying to adjust his strategy accordingly. And I think through his cross-examination, he's definitely advanced his theory of the case. And in addition, he has most certainly undermined the credibility of Robert Durst here. So I think that he's already been successful in this cross-examination, and I'm not sure how much more he's gonna be able to squeeze out of him here.
When you stand well, stand still. Gigi, you come from your dad who's a lawyer. We share that similarity as I come from a dad who's a lawyer. So we've been in this trial milieu our entire lives. You're the defense attorney, Dick DeGuerin, sitting there listening to all this. Do you need to go home and eat a hot dog and just suck your thumb and go to bed? Or are you ready to go on the attack?
You know, I'm more of an ice cream girl. I like to, lay in the fetal position and eat ice cream after this type of brutal cross-examination by a state attorney. But I don't try to sit there too long. I'm definitely thinking about ways to attack this and rehabilitate him somehow. But the ice cream definitely helps, Bob.
Yeah, real quick, do you expect that the prosecutor is going to say they had to go through all this more black stuff, all this other stuff with Kathy Durst because they didn't have a case other than that cadaver note, which is explainable? Is that where the defense goes in theory at summation?
Ooh, yeah, I think so. And I think they're trying, I think the defense is also going to try to go to his memory lapses as well.
All right. All right, Gigi. Listen, always awesome to have you on. Thank you so much for your excellent commentary, as always. This is it for me for the week. I will be back Monday and Thursday next week, 12 to 3. You can find me at rbianchiesq on Twitter and Gmail. But don't go anywhere. Anjanette Levy is next. You're in very capable hands. Have a great rest of the week.